Hello everyone. I, Foram Patel from LG School of Law would like to welcome you all in the sessions of the copyright under the law of the intellectual property. Now, we shall be starting with the understanding of the concept of the copyright once we have gone through the overview of the intellectual property rights. In this session, we shall be covering the meaning of the copyright, the history of the copyright, rights of the copyright owner, then acts, different provisions and remedies and infringement of the copyright laws. Before we move on with the understanding of the meaning of the copyright, I would like to throw a light on the history of the copyright concept in our country. So friends, let's get started with the understanding of the history of copyright concept. Friends, the modern copyright law developed in India gradually in what we may identify roughly as three distinct phases spanning more than 150 years. Now, the phase 1 was very well known as the East India Company Statute. Copyright law entered in India in 1847 through an enactment during the East India Company's regime. According to this enactment, the term copyright was for the lifetime of the author plus 7 years post-mortem. But in no case could the total term copyright exceed a period of 42 years. Now the government could grant a compulsory license to publish a book if the owner of the copyright upon the death of the author refused to allow its publication. The act of infringement also under this act comprised in a person's unauthorized printing of a copyright work. Very importantly, unlike today, the copyright in a work was not automatic. Registration of the copyright with the Home Office was mandatory for the enforcement of these rights which has been provided under that act. However, that act also specifically reserved the substances of the copyright in the author and his right to sue for the infringement to the extent which is available in the law in that enforcement. When this concept was first introduced in our country, my friends, the copyright law had already been under the development in Britain for over a century, and the provisions of 1847 enactment reflected the learnings from the deliberations during that period. Thus, in its very first avatar, the copyright had arrived in India as a modern law that was both abstract and forward-looking in its own nature. As a result, many of the philosophical debates over the nature of the literal property that had animated the initial years of the copyright development in Britain was conspiciously by the absence in its subcontinentals. If we can state in a very precise manner that 1847 enactment operated very little which is known. However, that enactment created the concept in our country to be developed with the passage of time in the further times. So phase 2 entered after the East India Company phase. The phase 2 was known as the Copyright Act of 1914, my friends. Now in 1914, the then Indian legislature enacted a new Copyright Act which merely extended the most portion of the UK Copyright Act of 1911 to India. It did, however, make a few minor modifications. Now, first, it introduced the criminal sanctions for the copyright infringement. Second, it modified the scope of the term of the copyright and also amended a little bit of the what you call sole right of the author to produce or rather reproduce or perform or to publish the work that has been given by that person. Vesting violation of the copyright rights with criminal sanctions can probably be understood as a part of the general colonial legal and political policies which sought to protect the rights of the property over the personal freedoms. The modifications of the term copyright for the translation of the rights, however, cannot be explained by any reference to dominant characteristics of that colonial policies. The language of that act might suggest a laudable policy objective of promotion of the wider diffusions of the Indian works in one language into other Indian languages, a consideration which might have operated or appeared to have a distinctive mark to India in compared to the UK laws. Now that act was continued with a minor adoptions and modifications till 1957 Act, which was brought into force on 24th January 1958, very shortly after the independence. Now, this phase of the copyright law generated some important classical decisions on the law of the copyright. So, the third phase, the new phase started after that time, which is known as the post-independence copyright laws. Now, independent India accorded high priority to formulation of its own laws on the copyright. The Indian Copyright Act 1957 repealed the Indian Copyright Act of 1914, which had virtually incorporated the whole of the Imperial Copyright Act 1911 of the United Kingdom. Now, the revision of this act occurred within a mere 7 years of its independence. For this whole modification, the Indian legislature appointed a select committee to propose a model copyright act. The committee appeared to have consulted the report of the English Copyright Committee, the model provided by the relevant international conventions, which received the evidence from the 12 organizations, including international confederations of the Society of Authors and Composers, which was held in the Paris, the Performing Rights Society of London, British Copyright Council, and the Columbia Gramophone Company Limited. Now, the report of the select committee, which was stated by Bakshiji, appeared to be the most amongst the briefest in the annals of the Indian Parliament, but in many sense it made major innovations which were ultimately enacted. Subsequently, after a gap of a whole decade, sweeping changes were introduced through an amendment in 1994, which included the increase of the term of the copyright from 50 years post-mortem to 60 years. The extension of the copyright of the new type of the work were included, such as computer programs and performances, and also the redefinition of the communication to the public, so as a work is communicated regardless of whether any member of the public actually sees, hears, or otherwise enjoys that work. Now, the next change that was made after a decade was that a vocabulary employed in that act. For instance, substituting the broadcast word for the radio diffusions, the work of architectural in the place of architectural work, sound recording in the place of the records. Now, the next change which was brought was that clarifications of the owner of the copyright over the public speeches and the works by the public undertakings. Post that, in the year 1999, certain sections relating to the international broadcasting rights were inserted into the Act, along with stipulation enhancing the fair dealing rights of the users of computer programs. These permitted the doing of the act which is necessary to obtain information which are essential for the interoperability of the computer programs, and also permitting the making of personal copies and adoption of the computer programs if they were legally obtained. Now, the history of the Copyright Act, as we saw, is characterized by a tendency to expand the commodifications of the culture, while at the same time it is constricting the access to it. So, this is what we can conclude, and we can comprise the whole history of the copyright concept in our country. It started with the East India Company till now, which is with a very vast modification and changes. So when we are starting with the concept of the copyright, it is very important for all of us to understand the meaning of the copyright, my friends. So let's get started with understanding the meaning of the copyright. Now, as you can see on the screen, the exclusive and assignable legal right given to the originator for a fixed number of the year to print, publish, perform, film or record the literary, artistic or musical material. That is what you can conclude and combine under the concept of the copyright. Now, under section 13 of the Copyright Act 1957, the copyright protection is conferred on the literary work, dramatic work, musical work, artistic work, cinematographic films, sound recordings, computer programs, etc. Now, for example, books, computer programs are protected under this act as a literal work. That is the meaning that the copyright concept has been gone wider in its own nature, and it has included all the possible creativity of an individual under its meaning so that to get the protection under the act. Now, there must be a question in all of our minds that why do we need to protect the copyright, or why should copyright be protected? Copyright ensures certain minimum safeguards to the right of the authors, my friends, over their creations, over their intellect, thereby protecting and rewarding their creativity also. Now, creativity being the keystone of the progress, no civilized society can afford to ignore the basic requirement for encouraging the same. Economy is not the only criteria on the basis of which the development can take the place. The parameters of the development has to be the creativity, their own reward, their own creations, their own intellect. And economy and social development, if we are seeing as on the screen of the society, is dependent on the creativity. That means, my friend, that without creativity, economy cannot develop as it has to develop. The development of the economy will be stuck at a point if the creativity no longer would be there. The protection provided by this act is to give is for the efforts of the writers, then the artists, designers, musicians, architects, and producers of the sound recording, cinematography, films, or computer software also. They create the whole atmosphere in such a way that social development is also possible when the rights of that individual is protected. Now, as you can say that the whole copyright, it is covering all the aspects as we have seen in the previous slide. That is the atmosphere that has been created for the whole intellect. Then to protect that intellect, to protect the work which is the outcome of that intellect, it becomes very important to protect the same so that the social development can take place, the economy can boost. The whole idea of having the copyright law in our country will be justified. So friends, this was the whole session with regard to what is the origination of the copyright concept in our country and the understanding of the term copyright, or rather the meaning of the copyright. In the next session, we shall be starting with the scope of the copyright, originality and other aspect with regard to the copyright laws in India. Friends, till then, keep learning and stay tuned. Thank you.